Welcome back to the deep dive. You are a listener. You came to us with a really focused mission, gaining deep, actionable knowledge on a topic that is, let's be honest, notoriously complex.
Yeah, estate planning in the state of Florida.
Exactly. And it's arguably one of the most critical legal challenges for anyone who lives there, retires there, or even just owns property in the Sunshine State.
It is. Florida's appeal is obvious. The environment, the tax landscape for many, but its laws, the specific state laws governing how your assets pass or, I guess, fail to pass, they are unique.
And really strict.
Incredibly strict and often completely counterintuitive.
Right. So the scope of this dive is ambitious. We're not just giving you a general overview of, what a will is. We are unpacking a whole stack of sources that detail the 7 most common, most egregious,
And most financially costly.
exactly, the most costly estate planning mistakes that Florida families are making right now in 2025.
And we really have to emphasize this. These are not minor oversights like a typo. We're talking about errors that can result in hundreds of thousands of dollars in unnecessary fees.
Not to mention crippling legal complications.
Crippling complications, delayed distributions, and maybe the worst part, the complete failure of what you wanted your legacy to be.
Yeah.
But the key is they are entirely preventable.
If you're vigilant.
If you're vigilant, yes.
So our mission today is to synthesize these 7 deadly pitfalls into really clear categories. You won't just hear what the mistakes are. You'll understand the precise legal mechanism that failed, the financial fallout, and what immediate fixes are proposed in the source material we analyzed.
We're basically stripping away all the jargon and giving you a roadmap to make sure your intent actually matches your execution.
Okay, let's unpack this. Let's jump right into our first major category. We're calling this the principle of override. This is where the legal system basically tells you, we don't care what your will says, we care what this one specific form says.
It's the painful truth of estate planning, really. The simple administrative upkeep, it holds more legal weight than all the sophisticated legal work.
Okay, so that leads us right to mistake number 1. Outdated beneficiary designations on retirement accounts. It seems almost too simple to be catastrophic, but the sources show this one error is a financial landmine.
The rule is absolute. It's non-negotiable, especially in Florida. Your retirement account beneficiary forms, so we're talking about your IRAs, 401ks, 403bs, pension plans, annuities, they legally trump everything else.
Everything.
Everything. They're what's called non-probate assets, which means they just bypass your will, they bypass your trust, and they go directly to whoever's named on that form.
So they execute immediately upon death, and that form is the final word. It's the legally binding instruction.
It's the final word, and the sources highlight this with just a truly shocking anecdote.
The case of the Stewart businessman.
That's the one. He passed away, had a substantial estate, including an IRA valued at $1.8 million. His current will, all of his documented intentions, they were crystal clear. This wealth should go to his current wife and their children.
The standard logical thing to do, protecting your current family.
Absolute logical, except the beneficiary form on file for that $1.8 million IRA still listed his ex-wife.
Oh, no.
And the divorce had been 8 years prior. This wasn't something that happened last month. This was a fundamental failure of maintenance for nearly a decade.
So what was the result? I'm almost afraid to ask.
It's devastating. Florida law mandated that the entire $1.8 million pass directly, automatically, to the former spouse.
And there was no recourse. The current wife and kids couldn't challenge it.
No legal recourse, because the beneficiary designation is the primary controlling legal document for that asset. 8 years of a new family, new intentions, all of it just nullified by one unchecked box on a form he probably forgot he even had.
It's fascinating because the effort to change that is so minimal, right? You log into a website, you fill out a piece of paper.
Minimal effort, but its legal authority is immense. The consequence here wasn't just a dispute. It was the total redirection of a fortune to someone who was never meant to get it, all from a lack of simple maintenance.
So the fix that's proposed is urgent. You have to review all of your retirement account beneficiaries immediately.
And it's not just checking the name. You have to look at the designation type. Is it per stirpes or per capita? Especially if you're naming multiple family lines.
Explain that difference, because that's a key detail people probably just gloss over.
They absolutely do.
Yeah.
So let's say you designate your 3 children. If one of them passes away before you do, per stirpes means that deceased child's share passes down to their children, so your grandchildren.
Okay, it stays in that family line.
Exactly. Per capita means that share is divided only among the surviving children. The deceased child's kids get nothing. That one word can drastically change your legacy if a tragedy occurs.
And the sources emphasize the timing here, too. They say you need to update these designations within 30 days of any major life change.
Any marriage, divorce, a birth, or the death of a beneficiary. That 30-day window, you should treat it as a hard deadline.
Now, what about more advanced planning? The sources mention naming your living trust as the beneficiary.
Yes, this gets a little more complex, and you definitely need professional tax analysis. But the benefit is huge. It's all about control.
Right, because if you name the trust, the funds don't just go to a person as a lump sum, they flow into the trust structure.
And that allows you to use strategies, things like conduit trusts or accumulation trusts. These help you manage the required minimum distributions, the RMDs, and those rules are always changing.
The old stretch IRA rules.
The stretch rules, exactly. This protects the assets for the long term, especially for younger heirs or maybe someone who needs special protection from creditors or, bad decisions.
So it's especially critical for tax-deferred accounts. Naming the trust lets you dictate how and when the money is paid out.
Which can extend that tax deferral period for as long as possible. Otherwise, your heir might get a huge lump sum, and with it, a huge immediate tax bill. This changes it from a direct payment into a managed strategic flow of wealth.
So mistake number one really teaches us that execution, the simple paperwork, matters more than intention when it comes to these non-probate assets.
It does.
And that transitions us perfectly to mistake number four, which is really the same concept, failing to properly title your assets. Just like that beneficiary form, how an asset is legally titled dictates where it goes, no matter what your will says.
This is the second pillar of that principle of override. People spend all this time and money setting up a great estate plan, and then they forget the follow-through. They forget to actually connect their assets, the house, the brokerage account, the bank account, to the plan itself.
Let's quickly review the different titling mechanisms the sources mentioned, because this is where the mistakes happen.
Okay, so first you have joint tenancy with rights of survivorship, or JTWROS. This is really common for, say, siblings or unmarried partners who own property together.
And what does it do?
When one owner dies, their share automatically and immediately passes to the surviving owner. It completely bypasses probate, which is great for speed, but it also completely nullifies anything you wrote in your will about that specific asset.
So if your will says, I leave my half of the cabin to my daughter, but the deed is JTWROS with your brother.
Your brother gets the whole cabin, your daughter gets nothing. The deed wins.
Okay, then there's tenancy by entireties, or TBE.
Right. And this is a Florida-specific designation. It's reserved only for married couples. It is the gold standard of protection.
How so?
Well, it also automatically transfers ownership to the surviving spouse and avoids probate, just like JTWROS. But, and this is the huge benefit, it offers powerful creditor protection.
So it's not just about inheritance.
Not at all. In Florida, if an asset is held as TDE, it's protected from the individual debts of either spouse. A creditor can only come after that asset if the debt was incurred jointly by both spouses.
So failing to title your marital home that way is a huge mistake.
A massive mistake. You're exposing your biggest asset to individual creditor claims unnecessarily.
And the third one is trust ownership.
Right. If you title the asset in the name of your revocable living trust, then the trust's instructions control everything. This gives you maximum control, maximum privacy, and again, it avoids probate. Mistake is when an asset, say your main brokerage account, is still in your individual name when your whole plan is built around the trust.
So what are the financial stakes of getting this wrong?
They're enormous.
Yeah.
The source material, it actually puts a number on it. For, let's say, a $5 million estate, just getting the titling right can save you somewhere between $150,000 and $400,000.
Wow. That's a huge margin of error.
It's massive.
Yeah.
And that's money saved by avoiding unnecessary probate fees, state administrative costs, and maybe some unexpected tax problems.
And on the flip side, getting it wrong is just devastating.
It's the number one reason trusts fail to avoid probate. You have this 1,000-page trust sitting in a vault. But if your house is still titled in your individual name, that house is going through probate court. It also leaves assets open to all the creditor problems that TBE or trust ownership was supposed to solve.
So the fix here requires a level of discipline that, frankly, most people don't have.
It does. You have to conduct a comprehensive asset inventory annually. You need to actually pull the deeds, the bank signature cards, the brokerage statements, and you have to manually look at the titling of every single account. You can't just assume it was done correctly.
And the sources say to focus on the big ticket items first.
Absolutely. Your real estate, especially if you have more than one property,
Yeah.
any business interests you have, and definitely investment accounts over a certain threshold, maybe $100,000. These are the places where a titling mistake has the biggest financial impact.
So this whole first section is about alignment. Your titling, your beneficiary forms, they have to be perfectly aligned with your will and trust, and they have to comply with Florida law.
The strategy, which is your will or trust, is only as good as the administrative tactics you use to connect your assets to that strategy.
And that leads us perfectly into our second section, which is all about those jurisdictional challenges. We're moving from administrative failures to legal failures that are based purely on geography.
Right. We're focusing on the legal specifics that make Florida estate planning so challenging, especially for the thousands of people who are relocating there every single year.
This is a huge issue. People move from New York, from Ohio, from Illinois, and they think their legal documents are portable, like their sofa. This brings us to mistake number 2. Using out-of-state estate planning documents without a full Florida legal review.
This is what we call the Florida exception. It's what makes this mistake so common and so dangerous. Florida has some of the most unique, most rigid estate planning laws in the country. A document that was a masterpiece of legal work back in your home state can be completely non-compliant or even useless in a Florida probate court.
Let's get into some specifics of that non-compliance. The first one is pretty straightforward. The handwritten will.
The holographic will, yes. In some states, a will that's written entirely in your own handwriting and signed, even without any witnesses, is considered valid.
But not in Florida.
Florida explicitly does not recognize them. So if you move from one of those states and that handwritten will is all you have, as far as Florida is concerned, you died intestate.
Meaning you died without a valid will.
Exactly. And that means the state's statutory rules take over. The law decides who gets your property, and it completely overrides all of your wishes.
And it goes beyond just how the document is created. There are administrative rules too, right? Like who can be your executor?
Yes. The people you named as executors in your old will, maybe a trusted family friend or your longtime accountant, they might not even qualify to serve if they don't live in Florida.
Right.
Florida has specific residency restrictions on who can be a personal representative. If they aren't a direct relative, like a spouse, child, parent, sibling, they generally have to be a Florida resident to serve. This is a common trap for people who retire to Florida but want their trusted advisor from back home to handle things.
And what if you brought a trust with you? That seems like it should be more portable.
It can be another minefield. Out-of-state trusts, especially the irrevocable ones, they often need significant revisions to comply with Florida law. The rules are different for trustee authority, for beneficiary rights, even for how real estate is managed within the trust.
So the consequence of using these incompatible documents is pretty much guaranteed to be a mess.
It's guaranteed to be a costly, long probate process with a lot of family disputes. The court has to spend time and money trying to interpret documents written under a totally different legal system. Or worse, just throw them out entirely.
So the fix, again, is time-sensitive and really not negotiable.
Not at all. You must get a qualified Florida estate planning attorney to review all of your documents, your will, your trust, your powers of attorney, within your first year of establishing residency there.
It's not optional. It's a compliance check.
It's a mandatory compliance check to make sure your legacy will actually work in your new home state. And that review needs to include a Florida-specific power of attorney, because the rules for witnesses and the required wording can be very different.
Okay, now let's tackle the issue that probably gives Florida attorneys the most gray hair mistake number 3. Ignoring Florida's unique homestead laws.
Homestead. This is where state law exerts its most powerful and often its most disruptive control over your wishes.
There's a dual nature to it, right?
Exactly. You have to grasp that. On the one hand, it's an incredible protection. The law provides this powerful, almost absolute creditor protection for your primary residence.
Which is a huge reason people move there. Creditors generally can't force the sale of your primary home to pay off your debts.
A massive advantage. That's the blessing. The curse is that the very same law imposes incredibly strict, non-negotiable limits on how that home can pass after you die. The state literally dictates the distribution if your instructions violate the statute.
And the key part is that a surviving spouse or minor children have guaranteed rights.
Guaranteed rights that cannot be overridden by your will or your trust.
Yeah.
This is where the conflict always happens.
Give us a clear example of how that conflict plays out.
Okay. Let's say you have a husband in a second marriage. He has adult children from his first marriage. He wants his current surviving wife to be able to live in their home for the rest of her life, but when she dies, he wants the house to go to his kids.
Seems perfectly fair and logical.
You'd think so. But if he tries to do that by just leaving the home solely to his adult children in his will, Florida law says no. It overrides him. If the home is titled just in his name and he's survived by a spouse, that spouse automatically gets a life estate in the property.
A life estate. So she gets to live there, but she doesn't own it outright.
Correct. And his adult children get what's called the remainder interest. The law forces this outcome.
Wait, so it forces a co-ownership situation?
It forces a co-ownership that is often a complete disaster. It creates immediate management headaches and long-term conflict. The surviving spouse has the right to live there, but the children, as the remainder owners, are often responsible for things like major repairs and capital expenses. They can clash severely over who pays for a new roof.
And the house becomes basically unsellable.
Exactly. The family relationship often suffers irreparable harm. So that raises the big question, right?
How do you get the benefit of that strong creditor protection without getting trapped by these restrictive distribution rules?
You have to use specialized planning techniques, and you have to be incredibly precise with the legal language. The fix involves structuring the home's distribution in full compliance with the law.
What does that look like?
Well, one way is for the spouse to waive their homestead rights. This can be done in a prenuptial or a postnuptial agreement. But that agreement has to be executed with incredibly specific language and process to be valid under Florida law.
Or, as the sources suggest, you can use other tools, like a life estate deed or a qualified personal residence trust, a QPRT. How does a QPRT help?
A QPRT is mainly an estate tax tool, but it can be used here. It lets you put the home into a trust while you keep the right to live there for a set number of years. The key is that the transfer has to be done properly, and the final distribution from the trust still has to respect the spouse's rights unless they've been properly waived.
So it's a delicate balancing act.
A very delicate balance. The takeaway on homestead is that this is the one area where Florida law is most likely to just outright invalidate what your will says, not just redirect an asset.
Okay, moving on. Our third big category shifts the focus. We're moving away from death and distribution and looking at the administrative failures that happen during life and potential incapacity.
Exactly. Estate planning has to account for illness and long-term care, not just the moment you pass away.
Which brings us to mistake number 5, inadequate incapacity planning. This feels like a huge blind spot for so many people.
It is. People see the will or the trust as the finish line, and they just neglect the very real possibility that they could become unable to manage their own affairs tomorrow.
And the gap is huge. Plans focus on transferring assets after you die, but they neglect how those assets are managed if you're still alive but incapacitated.
And the cost of doing nothing here is severe, and it's immediate. Without proper Florida-compliant documents, the family is forced into guardianship proceedings.
Which is a public, intrusive court process.
It is. It's costly, it's time-consuming, and a judge decides who should manage your life and your money. And the cost data from the sources is really striking.
How much are we talking?
A typical guardianship proceeding costs the family between $15,000 and $30,000 in initial legal fees alone.
$15,000 to $30,000.
And that's a completely preventable expense, paid out of the assets that should be going to your care or to your heirs. And it's happening at a time when the family is already under immense emotional stress.
And it doesn't stop there, right?
No, the court-appointed guardian then has to file annual reports and accountings, which adds ongoing costs and administrative burdens. It just strips away your dignity and your control over your own life.
So the fix is to have comprehensive, durable financial and healthcare powers of attorney, POAs, that specifically comply with Florida law. What's the difference between a durable and a springing POA?
That's a great question. A durable POA is effective the moment you sign it, and it stays effective through your incapacity. A springing POA only springs into effect after a trigger event, usually when 1 or 2 doctors certify that you're incapacitated.
Springing sounds safer, maybe.
It sounds safer, but in practice, Florida law and most attorneys now favor the durable POA. It avoids the inevitable delay and arguments over when exactly the agent's authority should kick in. When a medical emergency hits, you need your agent to have immediate access to funds and medical records. You can't be waiting on paperwork.
That makes perfect sense. Time is everything in a crisis. The key, then, is to designate trusted agents who really understand your wishes.
And who can act effectively. And, critically, you have to maintain and update these. If your chosen agent, say your brother, gets sick himself or moves across the country, he might not be the best choice anymore. Regular reviews are essential.
Now we get to mistake number 6, which you mentioned earlier. It might be the most heartbreaking of all because it just nullifies all the work you did up front.
Failing to fund your living trust. It's the absolute classic blunder. A revocable living trust is a fantastic tool. It gives you privacy, it avoids probate, it gives you highly customized control. It's the primary tool for so many people in Florida.
But the sources are brutal on this point. They say the trust is essentially worthless if it's not funded properly.
And funding means one thing and one thing only: retitling your assets into the trust's name. You create this beautiful legal instruction manual, the trust document, but if you fail to actually change the legal ownership of your assets to the trust, it's just an empty shell. It owns nothing, so its instructions apply to nothing.
Because if the trust doesn't legally own the asset, the deed isn't in the trust's name, the bank account isn't titled to the trust, then the trust terms can't control it when you die.
The assets are still legally owned by you as an individual, and the consequence of that is devastating. Those individually titled assets have to go through probate.
So you paid all this money for a private probate avoiding plan.
And you're right back in public. Costly probate court. You paid for the solution, but you failed to actually implement it.
Let's get really specific here. What does systematically retitle all significant assets actually look like? Let's start with real estate.
Okay, for real estate, you have to sign a new deed. It could be a quitclaim deed or a warranty deed, and it transfers ownership from, say, Jane Doe, an individual, to Jane Doe, trustee of the Jane Doe Revocable Trust, dated whatever date.
And then you have to record that new deed, right?
You must.
Got
It
it.
has to be officially recorded with the county recorder's office. If the deed isn't recorded, the funding is not complete.
What about financial accounts? Brokerage accounts, bank accounts?
For those, you go to the financial institution and you fill out a new signature card or a new ownership form. The title changes from your individual name to the trust's name and tax ID, which is usually just your social security number for a revocable trust.
And tangible personal property, like cars or a valuable art collection.
For most tangible property, you execute a separate document. It's usually called an assignment of personal property. It's notarized and signed, and it says that all of your stuff is now owned by the trust. For really high-value items like a classic car, you might need to actually change the title with the DMV.
So the fix requires this meticulous follow-through with your attorney and your financial advisor working together.
It's the essential bridge between the legal theory and the functional reality. Without funding, the trust is just a magnificent, expensive document gathering dust in a safe deposit box.
So we've covered 6 very specific failures, but as we look back on them, they all seem to feed into one ultimate overarching flaw.
They do.
And that brings us to mistake number 7, not updating your estate plan after major life changes.
This is the time trap. It gets almost everyone. The sources say that most Florida families haven't updated their estate plans in over a decade. And think about how much changes in 10 years. Your assets change, your relationships change, your kids grow up, and the laws themselves change. The neglect is just systemic.
Let's run through those critical triggers again that demand an immediate review. It's not just death.
No. It's marriage, divorce, births, deaths, relocating to Florida, which we covered with mistake number 2, and any significant change in your wealth. Selling a business, getting a big inheritance, a major shift in your investment portfolio.
Because any one of those events can render your old plan obsolete.
Completely obsolete.
Yeah.
And we can see how this connects everything. Remember, the Jupiter retiree, he failed to change his IRA beneficiary after his divorce, and his ex-wife got the money.
That's mistake number 7, feeding directly into mistake number 1.
Exactly. And then there was that painful example of the client whose will left assets to a child who had passed away, but it made no provision for his stepchildren who had been part of the family for years.
The plan was just outdated. It reflected a family structure that didn't exist anymore.
And that lack of a simple review left the stepchildren with nothing, which was the opposite of the family's emotional reality. It's an emotional failure and a financial one.
So what's the recommended schedule?
The sources recommend a mandatory update schedule. Review your plan every 3 to 5 years, even if you think nothing has changed. This is the maintenance that catches the subtle errors.
But if one of those major life events happens, the review needs to be immediate.
Immediate. They even mention that smaller changes should prompt a document check, like opening a new bank account or buying a new property.
Because every time you get a new asset, you're creating a new titling question or a new beneficiary designation.
Right. If you open a new investment account and you forget to title it in the name of your trust, you've just created a new probate asset. So mistake number 7 leads you right back to mistake number 4 and number 6. Maintenance is the safety net that prevents all the other errors.
Okay, so let's synthesize all of this. We have the administrative override, the jurisdictional failures, the incapacity blind spot, and this failure of maintenance. What is the total compounded cost of inaction?
Here's where it gets really interesting. Because when these 7 mistakes combine, they don't just cost you a fee here or there. They create this multi-layered crisis that undermines the entire idea of leaving a legacy.
Let's run through the specific outcomes of the sort this detail. First, improper planning leads to unnecessary estate taxes.
Right. All these sophisticated trusts and titling strategies are designed to minimize or eliminate those taxes, but a flawed plan just exposes the entire estate to the IRS.
Second, the length and expense of probate. We've seen how not funding a trust or using an out-of-state will just drags the estate through public court for months, sometimes years.
And it just consumes resources and delays getting much-needed funds to your family.
Third, family disputes and litigation. This is the really ugly one.
It is. When the will says one thing and the beneficiary form says another, or when the homestead rules override what everyone wanted, families fight. And those fights destroy relationships and they burn through huge chunks of the estate in legal fees, the very thing the plan was supposed to prevent.
Fourth, the fundamental failure, assets passing to the wrong people.
The ex-spouse, an estranged cousin, whoever. The financial consequence of that mistake is irreversible.
Fifth is the complete loss of privacy. A huge reason people, especially high net worth people, move to Florida is for privacy.
But probate is a public record. All your assets, all your debts, your entire distribution plan, it's all exposed for anyone to go and look at. Failing to fund your trust guarantees that lack of privacy.
And finally, the sixth consequence, inadequate protection during incapacity. We talked about that $15,000 to $30,000 cost of guardianship.
And that cost is compounded by the emotional toll, the inability for your family to act quickly in a crisis. It can mean delayed medical care or missed financial opportunities because no one has the authority to act.
The overall solution that the sources keep coming back to is pretty consistent.
It is. These 7 mistakes are almost always preventable. It just requires working with experienced professionals who really understand Florida's unique, granular legal landscape.
And that professional team, the attorney and the financial advisor, they have to be integrated. They can't work in silos.
That's the key. The attorney builds the legal structure, and the financial advisor has to execute the asset titling and the beneficiary updates. Seamless coordination is the only way this works in Florida.
If the documents are the map, the funding and titling are the GPS coordinates. They have to match perfectly.
That's a great way to put it.
So this deep dive has really shown that estate planning, especially in Florida with its very specific laws, it's a system. It's a system of coordinated documents and continuous maintenance. It has to be treated as a live, evolving thing, not a one-time project you check off a list.
Absolutely. If you're listening to this and you recognize any of these gaps, if you've just moved to Florida, if your beneficiary forms haven't been looked at in 5 years, if you have trust documents sitting unfunded in a drawer, it is time to take immediate, definitive action. The costs of delay are clearly documented, and they are financially devastating for the people you leave behind.
You know, we started this discussion by pointing out that uncomfortable truth. That simple asset titling and beneficiary forms so often override these incredibly sophisticated wills and trusts.
Yeah, that administrative hierarchy. It gives the simple, often neglected paperwork more power than the formal witness legal document that an attorney drafted.
And that leaves us with a final provocative thought for you to mull over as you look at your own situation. If the administrative details, that click of a button on a website, the signature on a new deed, if they carry more legal weight and dictate the outcome more certainly than the formal notarized legal document itself, are we now living in a world where maintenance is legally and financially more important than the creation of your plan when it comes to protecting your wealth?
The longevity and success of your entire financial legacy really doesn't rest on the day you sign the papers, but on your ongoing vigilance.
Thank you for joining us for the deep dive.